Conversations across time, 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 conversations across time.
Good evening. Welcome to another interesting series from Conversations Across Time. We are going to be discussing for the next 3 weeks the Supreme Court of the United States. And this week we're starting off with the fact that there is no ethical rules guiding the Supreme Court. And our guests are, first of all, let me introduce, in studio with me is the cat legal expert, Irv Madnick. And Irv, you want to explain what it is you're going to do for us?
Sure. What I'm going to try to do is make the regular legal mumbo jumbo and talk about it in terms of common sense, so that everybody can understand exactly what we're talking about. Because these are really a lot of legal, clear legal definitions that are discussed in legal terms, and if I can make it a common sense proposition, I think everybody can understand it, and that's what I'm going to try and do.
That's great. That's great. Our next guest is Associate Justice Scalia.
Hello, I'm Associate Justice Antonin Scalia. I was appointed by President Ronald Reagan to be on the Supreme Court, and I embodied the conservative wing of the court. And you might remember I passed away in 2016, and I am here to give my own commentary.
And our next guest is the Honorable Thurgood Marshall.
I am Thurgood Marshall, representing justice and equality and also moral fiber in the court. I was appointed by President Johnson, served until 1991, passing shortly thereafter.
Thank you, Justice Marshall. And finally, we have with us Justice Oliver Wendell Holmes.
I'm Oliver Wendell Holmes. I was appointed to the Supreme Court by Theodore Roosevelt. I was a progressive, and I'm most noted for the doctrine that limited free speech by the use of the term clear and present danger. If you presented a clear and present danger to the United States or to other people, you were limited in what you could say.
And so for our discussion, one of the things that is most apparent right now is that there seems to be no ethical oversight for the Supreme Court. And historically, the Supreme Court has always been held up as this honorable institution. And I'd like you, if you would, to talk a little bit about Abe Fortas.
Okay. I can talk about Abe Fortas because this happened a long time ago, and we can bring it up to date to what's going on today in the Supreme Court. Abe Fortas was appointed by Lyndon Johnson as an Associate Justice in the Supreme Court back in the 1960s. I don't remember the exact date, but it was somewhere around 67, I believe, 66 or 67. Justice Warren was Chief Justice of the Supreme Court at that time. The Supreme Court had, a very liberal bent, and Abe Fortas sort of fit right into it. He had been a friend of Lyndon Johnson and helped Lyndon Johnson get elected to the Congress, and Lyndon Johnson eventually became vice president. And of course, when Kennedy was assassinated, Lyndon Johnson was president and appointed Fortas to the Supreme Court. When Chief Justice Warren passed, or left the Supreme Court, he nominated Abe Fortas to be the Chief Justice of the court. He had to be voted on by the Senate, and the Senate has to vote to make confirm the appointment of Chief Justice. Well, at that time, they found that he had accepted some money from what was it? Vivienne, do you remember at first?
Yeah, the first instance, and why he didn't become the Chief Justice, is that he had accepted, I believe, $15,000 to appear at various universities for speaking engagements.
Yeah,
and
it
they
didn't seem like a lot, but the Republicans in Congress made it a very, very big issue, and he was not named as Chief Justice. Shortly thereafter, evidence appeared that he had taken a lifetime retainer from the Lewis Wolfson Foundation, which was a charitable organization, and he was retained to represent them. The problem with that was that Lewis Wolfson had been convicted and was serving jail time for securities violations. Well, this gave the Republicans in the Senate an opportunity to impeach, in other words, to remove him from the Supreme Court through impeachment. Now, impeachment requires a hearing, of course, to impeach. Impeach is like an indictment. But they would impeach him, and then the senators would have to vote on it, and it would be a long, drawn-out process. Fortas decided that rather than go through that process, and he was still relatively young, and he would have had a vibrant law practice, he was well known, decided to resign from the court and not go through the impeachment process. So he was never impeached, and by the way, no Supreme Court justice had ever been impeached. Federal court judges, the lower court judges, have been subject to impeachment and have been removed by impeachment, some Claiborne in 1986 and a couple of other instances. But he retired and resigned from the court. He declared that he was innocent, which everybody who's even guilty declares they're innocent if they're ever charged with anything, and went on with his life. But there was apparently the ethical standard at that time, this was in 1969, showed that he could be removed from the court even if it was by resignation. You know, pressure was put on him and he resigned. Well, bringing it up to date, of course, with all the allegations against Justice Thomas and now Justice Alito about how much money they've been getting and these wonderful trips and private jet flights and hundreds of thousands of dollars in services that they have not even reported but are obviously true, means nothing because there is no formula, and the Congress has no ability to do so, and it's based on the Constitution. So this has become a major problem, especially, they sit on cases, and it's been shown that they sit on cases where they actually have a direct interest in how they know the people, and the people have been supporting them in different ways with cash and whatever.
And also because Thomas's wife is a lobbyist.
Yeah, she's very, very.
She's very active.
And not only that, she was very active in Trump's movement to stop the steal. I mean, all over. And cases came before the Supreme Court, and he never recused himself when he should have because his wife was involved in all these things. And now Alito has allegations against him that he's been taking, large amounts of money to speak at universities and whatever, and sponsor the Federalist Society and everything else that appoints these conservative justices. And once again, there's really no mechanism to do anything about it. And it's become really a major problem.
So that's it. That's the backdrop of the ethics that the Supreme Court held or the standards that the Supreme Court held itself to 1969, and probably until Scalia.
The bottom line is everybody assumed, and when I say everybody, I mean, I've been around the legal society for a long time. Everybody assumed that the Supreme Court was unbelievably ethical, and they were upstanding and whatever. And the Supreme Court always was held in high regard by everybody, not even, it wasn't Democrat or Republican, everybody, the legal community and the general public at large. Today, the polling suggests that they're not respected by very, very many people. I think it's a 70-30 and not in favor of the Supreme Court, which is incredible. And if they would institute some ethical standards that they would live by and make it public so that the general public knows that they're ethical and the decisions are based on on ethical considerations, I think it would go a long way in making the Supreme Court what it's supposed to be. And unfortunately, it's not at the present
Well,
time.
we've got fortunately visiting us 3 justices, and I'd like to hear from them, just in terms of what you feel about the way that the court is behaving today.
Well,
Well,
what Mr. Maddock said was quite correct, but the problem is it's up to the individual justices and under the leadership of the chief to believe in ethical standards of morality and do it. I wrote many articles about judges and that they can be influenced by a lot of other factors than just the morality and the legality of things. And the problem is there is really a very, very limited way that anybody else can regulate the court to accept the same standards lower court judges are forced to accept and most state judges are forced to accept. And that therein lies the rub. And Justice Scalia was one of the most egregious judges to utilize the ability to take things and vacations and hunting trips with people that were going to have cases before the Supreme Court. And he kind of schooled Clarence Thomas and Justice Alito that it was okay to do those things. So it's a personal thing. I'm sure Justice Marshall would have never behaved this way.
I am finding that the moral fiber of the court is significantly frayed. Abe Fortas happened to be a friend of mine, and he was an honorable man, and there was significant political influence to pull the thread of the string in that sweater that was ultimately forced him to resign. My time in the court, my experience is that there was a particular honor that the court itself had intrinsically, but that honor is undergirded by the honor that those who sit on the court bring with them. I find that there have been significant instances of people on the higher court who believe themselves to be above the law that they represent. Justice Scalia, I would agree, is among the most egregious and presents the kind of attitude that has now become a pariah and a bacterial infection to the current form of justice as it is supposed to be represented in the Supreme Court.
My honorable colleagues say just the sweetest things about me. And
well, I just want to ask you one thing, Justice Scalia, because I do want to hear from you, but I want to make sure that because it's our understanding that based upon an article in the Los Angeles Times in 2004, in which Clarence Thomas was disclosed as having accepted gifts, that you advised him. And that was as the direct result. And then he just stopped reporting anything. So please go on. But I just want to make sure our audience is clear. Up until 2004, Clarence Thomas wasn't declaring his wife's income, but at the same time, he was at least disclosing something. But you gave him some advice. And so I want to make sure in your response that you address that as well. I'm sorry for cutting across you.
Okay. Well, there's this one little loophole in the law reporting our whatever freebies or goodies we get, and that's a law of personal hospitality. I mean, saying that it's okay to accept these trips and hotels and lodges and stuff, so long as it comes from a personal friend. And that's the loophole that Justice Thomas has done. And I've done that a few times myself.
A few times.
And you have to understand.
Wait a minute. A few
we're an
times.
oligarchy.
Over 70 times. Over 70 times. You said a few times. I'm sorry.
Yeah, but
okay,
even if they're a personal friend of yours, Justice Scalia, you can't not recuse yourself from cases that they bring before the court. So even if you say, well, I accepted a gift and that was the technicality is it's legal from a personal friend, and then they have a case before the court in which their business is challenging a law before the court, and you don't recuse yourself, and no one can make you recuse yourself from the case, unlike other courts, then that's totally unethical, and I don't care what loophole you cite.
Well, let me just interject a legal point here, because we're talking about recusal. What recusal means, it means that they don't sit on a particular case because it's possible that a personal interest between them and the people citing that are in the case have an interest in it, and this way, if there's any kind of appearance of impropriety, then they can stand down and not sit on that case and judge that case. It's happened, it very rarely happens, by the way, but it happened most recently with the most recent appointment, Justice Jackson. The affirmative action case that came before the court involved Harvard University, and she was a graduate of Harvard University, and she stood down in that case. She recused herself. She did not participate in that particular case, in the judgment of that case. And that's an ethical standard that's very rarely been used by the Supreme Court, but should be used much more.
But contrast that with what Clarence Thomas did when the cases came up involving the January 6th thing and his wife's emails. He ruled on the case, and he was one or two justices that ruled that the case shouldn't be heard, and he didn't recuse himself, and it was his very wife. So you can't get any better reason to accuse yourself than it affects your own wife. So that's a great contrast you brought up, and I think that if you look at the record, there's been cases that Alito heard and Thomas heard, in which they were cases involving these very people that gave them gifts, who, quote unquote, they did it out of friendship. Well, I don't know about that.
Justice Scalia.
Friendship's a relative term, Justice.
Here's the problem. Let me tell you what the problem is. The Constitution created the Supreme Court. So the federal courts, the Constitution also delegated the Congress to create the lower federal courts in the different sections. And as a result of that, since the Congress has the right to appoint lower federal court judges, then they have the right to create ethical standards, and they can control that. But the Supreme Court, because it was created by the Constitution, they have to create their own ethical standards. And so far, or up until a certain time, I guess they did, but it's certainly not evident today with all of these unethical considerations that are going through the court between Thomas and Alito and even Sotomayor. I mean, there was an allegation against her. It's not just on the conservative side. So they do nothing. The Chief Justice has done absolutely nothing in this regard. And it's up to them to do it, and nobody else can because of the creation by the Supreme Court.
And they're not going to do it ever.
Mr. Madnick was the appearance of
yes,
correct,
impropriety.
Right.
And the honor of the court has been frayed because it seems that over time justices have had less and less concern about the appearance of what they do. In fact, in the cases of both Thomas and Alito, there is a brazen nature of it, which represents them as them believing themselves to be above the very law that they represent. The honor quotient, as I stated initially, there's the honor of the court that is, in fact, institutionally present as a tradition. And then there's the honor that one brings to the court. And it seems that there is less and less of that.
And that's why the polling is what it is and why the court has lost the respect of the general public.
Yes, well, it's true. We know about the appearance, but we don't care about appearance. We don't care about polls. We're pretty much a self-perpetuating oligarchy, and it'd be very foolish for you to think we're going to police ourselves. If we're going to take the goodies, the trips, and the hunting lodges, etc., we will, and there's nothing you can do to stop us.
But as I see it, if that continues and the public continues to lose respect for the integrity of the court, then when you make decisions, they're going to be less in terms of, well, we need to obey this. This is the final law of the land. This is what the law is, because people are going to question the motives of the justices who ruled in that case. And when you don't have public support for the institutions, and I was a big advocate of what the public wanted and what the public needed should be part of the jurisprudence of the law, then you don't have a court. Then the decisions the court made are just things that people hear, and they say, why should we obey it when it was political or influenced by donors, and it's not the true feeling of what is right and what is wrong. So that's the danger. And when Justice Scalia says we're never going to change it, then the court will be a paper tiger, to use a different term.
Well, let me just take that one step further.
Well, as long as we got our position and our freebies, we don't care. As a matter of fact, here's a little fact.
Well, I think there's some justices that are clear. I'm sure Justice Marshall cares and cared. I cared. There's some justices on the court now that care. So it's you and your ilk that don't care.
Irv, you were getting
Yes, I might remind you.
Interject something.
The court today, unlike the court in the past, when I say the past, I'm talking about the 70s, 60s, 50s, 40s, and when you guys were on the court, it's more political now. The court never seemed to be political, even though the justice might have been appointed by a Republican president or a Democratic president. They didn't vote because they were appointed by a Republican or a Democrat. They voted because they thought what they were voting on was correct based on the Constitution and the reading of the Constitution. The Constitution.
No better example of that.
Go ahead, I'm sorry.
The best example is Earl Warren, appointed by a Republican president.
Absolutely.
Who ruled on Brown versus the Topeka School Board, which Justice Marshall was the attorney for the NAACP in that case. So that's the best example you can possibly give, and I agree with you 100%.
And Justice Douglas, who was appointed by a Republican judge, voted on and on with all of the the criminal cases that were brought before the court, and Fifth Amendment cases, and the right to search and seizure, and confessions and whatever, and voted in favor of all of those. All of those decisions. So that happened regularly. That's not happening today. I mean, the court is clearly
totally
split
politicized
between Republicans and Democrats, conservative Republicans and Democrats. And
a memory that I have that relates directly to what happened to Abe Fortas is that the zeal to go after him was motivated muchly by President Nixon's desire to change the fabric of the court. So these political undertones are currently have always been present. However, now they are brazen and unchecked.
Yes, I have
And the other,
excuse me, Justice Marshall. I'll have to agree, Counselor. It is the court has been very much politicized. Like so many federal judgeships, including the Supreme Court. The candidates mostly have come out of the Federalist Society, a group of conservative attorneys and judges. And to be honest, I helped organize the chapter in the.
You're one of the founding members of the Federalist Society. Right. You're one of the founding members. You're one of the founding members of the Federalist Society.
Well, yes, the Federalist Society started in the 70s, and their goal was to put as many conservative justices on the Supreme Court as possible. And when
it worked,
this passed, that when Trump was the president, Trump didn't pick these people to be. He had 3 justices that he appointed to the Supreme Court. Very unusual for a president who only serves 4 years to have 3 appointments, but he did because of the way McConnell, gerrymandered the court process,
and would not allow
wouldn't allow a justice who would have been Garland, who's now the Attorney General, appointed by Obama in the last year of administration, said it shouldn't be done, and yet in the last year of Trump's administration, he had 2 justices that were appointed, and he said, well, this is now and that was then. Well, that was terrible. But the Federalist Society, over the years, has created a list of people who they know have conservative viewpoints and values that they want on the board, and they gave that list to Trump, and those justices were directly appointed by the Federalist Society and not by Trump.
Even the judge in Florida who was going to be she's sitting on the case, right, having to do with January 6th with the documents, because the documents were recovered from Mar-a-Lago. So that's why the jurisdiction is in Florida. And that judge is, she's a Trump appointee, but she's also a member of the Federalist Society.
Absolutely. He appointed up maybe 130 or 140 lower court, below the Supreme Court, federal judges in the country. But we're going to talk about, in our next segment, we're going to talk about Judge Cannon and her influence in Trump's case and Trump in general and how it affects the Supreme Court. But today it's very politicized, and probably the major reason, along with the ethical considerations, why the polling is such that 70 or 75% of the public don't respect the Supreme Court or its opinions. And of course the Dobbs case certainly had a lot to do with the overruling.
I think it goes back further than that. I think that the first, I mean, there's always been political considerations when you had slaveholding judges ruling on Jim Crow cases and things like that.
Well, the Second Amendment is a perfect example.
But I think the modern politicalization of our court was Bush versus Gore and that decision.
And on that note, this has been another Conversations Across Time. I want you to tune in next week, because then we will continue our discussion of the Supreme Court, and we'll also have an explanation and some illumination on clear and present danger and how that fits into what is happening today. So thank you very much. Irv, thank you so much.
My pleasure.
And to our audience, we thank you. And Justices Scalia, Marshall, and Oliver and Justice Holmes will be returning next week so that we can discuss the Supreme Court and clear and present danger. Thank you very much. Good night.
Conversations across time. Conversations across time. Across time. Conversations across time. Conversations across time. Conversations across time. Conversations across